trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome to another episode of Miscellaneous Cases. I'm just kidding. Yeah, this double ratio thing, it's kind of got me confused. It seems like the other that's for the TV stuff and the cell phone one gets more views than the regular. So I'm kind of playing it at ear, right now. So yeah, welcome. Everybody is welcome here as long as you behave yourselves like adults. And when you can't, then you will get timed out. So that's why you see where my response was on there twice, because it's having to respond twice to. So hello EMS. Hello to everybody. Today is just miscellaneous cases. It's just the way I had it scheduled for the coming up week. Each week it's going to be a different judge. So I have it scheduled out. So today let's start out with, I guess that's Judge Kristen D. Simmons' courtroom. So let me share this. We go back to StreamYard and make it bigger. Excuse me.
On the record in the matter of the state of Michigan versus Mark Anderson, 5-02492 of please.
Thank you, Your Honor. Cassidy Kachugas with people appearing or request permission to practice pursuant to MCR 8.120 with Jen Lawson as my supervising attorney.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Mark Anderson, who appears today via telecom from the Ingham County Jail.
Okay, today was the date that was set originally for a preliminary examination. The court did find good cause to adjourn the timeline with the understanding that there would be a competency evaluation needed. The court's not received any paperwork.
Yes, Judge, I thought that had been, it's my fault, to be clear. I thought it had been already filed earlier this week. I did bring, it apparently was not. I did bring it today, if I may approach.
I think you have a copy of your complaint. Are you intending to attach that?
Oh, I intended to attach it in case the court wanted or needed it.
So, order for the defendant to undergo a competency evaluation has been signed, and the case will be set for internal review. See when we get our report, okay?
Thank you.
No problem. Any additional matters to the record?
Nothing, Your Honor.
Not from the defense, just thank you.
Thank you. You can let them know you're all set in the jail, okay, sir? Thank you, Mr. Anderson. Let's see. That's Schuster. Who's representing Mr. Schuster? That's you as well?
I'm covering it today, Judge, yes.
Okay. This is the State of Michigan versus Adrian Schuster, 25-02219. Appearance, please.
Your Honor, Cassidy Kachugas with people.
Good afternoon, or good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Schuster, who appears today via Polycom from the Ingham County Jail. I'm covering for his attorney of record, Aaron Robinson, also.
Okay, I do have a pre-sentence report that was prepared on August 27th. You got a copy of that, counsel?
I do have a copy of it, Your Honor, just so the court knows I did meet with Mr. Schuster in a breakout room this morning and reviewed the PSI, so we're prepared to proceed.
No need to make corrections, updates or deletions, or do we need to make some?
I do not have any corrections, Judge.
People do not have any either, Your Honor.
You can make allocation.
Thank you, Your Honor. The recommendation from the pre-sentence investigation is that Mr. Schuster be sentenced to time served, that being 47 days. He's been in custody at the Ingham County Jail for that period of time, I believe since July 21st. Mr. Schuster, as indicated in the police report, or excuse me, in the PSI, Mr. Schuster is currently on parole with Michigan Department of Corrections. He is yet to face sanctions for that. The PSI is recommending time served in this matter because regardless of what happens in this case, he will remain under the custody and subject to sanctions by the Michigan Department of Corrections. It's unclear at this point what is going to happen, whether he be released on tether through them, whether he be returned to prison, or whether he be sent to something in between, that being a halfway house or some sort of rehabilitation. Mr. Schuster does acknowledge, as indicated in the pre-sentence report, he does acknowledge that substance abuse, and particularly methamphetamine, has been sort of the underlying driver of his criminal trouble. He's taken responsibility for both the case that he's before the court on and his ongoing substance abuse. And I think that the Department of Corrections is looking at taking action to further address some of that substance use. And so in that regard, Your Honor, we're asking the court follow the recommendation of PSI, sentence Mr. Schuster to time served, and allow the Department of Corrections to take whatever action that they're going to take.
Want to be heard at all?
Just briefly, Your Honor, I don't think that defense counsel or the PSI is inappropriate at this time. I do think it would be appropriate to simply just permit the parole board to handle this matter how they see fit.
The court agrees. The sentence of the court is credit time served. That switches to you, Mr. Schuster. You're all set.
Thank you.
You're welcome. The state of Michigan versus Mark Rubin, 25-02468, appearance, please.
Thank you, Your Honor. Cassidy, could you speak for the people?
Good morning, Your Honor. Christopher Wickman via Zoom this morning with Mr. Rubin sitting to my right.
Today was the date originally scheduled for preliminary examination. The court did indicate that we would treat today as a probable cause conference and waive the timeline as necessary. There was some additional discovery being sought. Counsel, did you get the discovery?
Good morning, Your Honor. I did not receive the discovery yet, but we have had some kind of updates in progress. I emailed with the Discovery Department last week extensively, and then Cassidy did follow up this morning with regards to the status of it. It looks like we are moving forward, but specifically the phone, which is kind of an important piece of this. It looks like that phone dump is maybe starting or in process. So we would ask for a later date for it to be set.
Your Honor, that is accurate. However, I do anticipate that the phone dump may take, it is a phone dump that is being investigated as if it may contain CSAM, and as such, it may take a couple months for that phone dump to come back, and I've communicated that to Mr. Wickman at this time.
So it sounds like it might be more than just a couple weeks before you can get the discovery you're seeking. Either way, this matter is going to have to be reset because we're not prepared to proceed today. And is your client willing to waive the timeline?
Yes, Your Honor, we've had that discussion today.
Mr. Rubin, you understand your right to have a preliminary examination within 21 days of the date that you were arraigned.
Yes, Your Honor.
And are you willing to waive that 21-day timeline so this matter can be reset, allowing your attorney to hopefully receive the discovery he's seeking to help prepare for your defense?
Yes, Your Honor.
Okay, is anyone threatening you to waive the timeline at all?
No, Your Honor.
November 14th. At 9:30. November 14th at 9:30 work for you, Mr. Wickman?
I'm sorry, Your Honor. Did you say November 14th?
November 14th, correct. That's a Friday.
I'm currently scheduled to be in trial with Judge Kennedy on November 14th, Your Honor. That would be day 3, and I do expect it will go at least 3 days. If the
November
court-
20th.
November 20th, yes, Your Honor. What time?
9:30. At 9:30.
Thank you very much, Your Honor.
We'll probably see you in person November 20th at 9:30. Any additional matters for today's record?
Not for the people, Your Honor.
Your Honor, just on this one, I would just ask the court to take a look at the bond conditions. This is not a case involving firearms, alcohol, drugs, anything like that, medical marijuana, any of that. So I would just ask the court to, if the court would be willing to take a quick peruse over that. The allegations here are that my client supposedly met up with someone online in the middle of the day and things like that. So I think that those bond conditions are not rationally related. Just if the court wanted to review the bond conditions, I'd appreciate it. Thank you. And my client hasn't been in trouble in 20 years on anything, and it wasn't alcohol, drugs related before either, or firearms.
Okay, looks like standard conditions were imposed at the time of arraignment. Not to possess a firearm, ammunition, or weapon of any kind, no drugs or alcohol without a valid prescription, no travel outside the state without prior approval of the court. And the people want to respond.
Your Honor, those are our standard conditions for a reason. I mean, the no drugs that are not prescribed to you is basically don't commit a crime. I think it's appropriate to have the defendant remain in the state, considering he was seeking to meet up with a minor. Oh, that he met over the internet. It was a chat sting case. That minor, fortunately, did not actually exist in the situation, but given that he was seeking to meet up with a minor, I think we should restrict maybe the area that he is traveling to still be within the state. And also refer to your discretion.
And just to clarify, Your Honor, we're not asking to waive this actual standard conditions that are non-optional, such as not leaving the state or anything like that. I just don't know that we need to ban alcohol, marijuana, or firearms when they aren't remotely relationally related to the case. Thank you.
Thank you. I don't see any reason to deviate from the standard in this particular case. These are very serious and concerning charges. And so the bond as set by the magistrate will continue. Any additional matters?
Not for you, Your Honor.
No, Your Honor. Thank you for reviewing that.
No problem. Thank you.
Have a good day, everyone.
Same to you. On the record in the matter, is the jail here? This must be, is it Cheney, maybe? Okay, Ms. Donnelly's here. Let's take care of that. On the record in the matter of the state of Michigan versus Brian Cheney, 25-00249, appearance, please.
Thank you, Your Honor. Can I speak to you for the people?
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of defendant Brian Cheney, who is appearing by video.
Thank you. Mr. Cheney was previously denied a public defender. It looks like he now has the office of the public defender.
Yes.
Okay. So today was the date scheduled for preliminary examination, but because he did not have an attorney, we elected to treat this as a PCC. And then my understanding is there is the potential for a competency referral.
Your Honor, I will, I met with Mr. Layton for the first time yesterday briefly, so I wanted to meet with him again after we're done here. If I could get a breakout room with him to go over a couple more things, and then I'll talk to him more next week.
Mr. Cheney?
Mr. Cheney.
Oh, you said Mr. Layton. That's just.
Oh, I'm sorry, that was my other client this morning. I apologize.
Mr. Layton is.
Confused.
Okay. All right, sounds good. So the court's going to find good cause at this point to go beyond the 21-day timeline due to the delay in appointment of the public defender's office and then the potential for need for an evaluation. Now, you can log in and meet with your client, and then if you are going to proceed with a competency, you can let us know.
Okay.
Otherwise, we're going to go ahead and set this for another exam date, okay?
Yes.
September 18th at 9:30. September 18th at 9:30.
9:30.
You have any questions for the court today, Mr. Cheney?
No.
Okay, hang tight. Your attorney's gonna log in and meet with you.
Okay.
Thank you, Your Honor.
You're welcome. On the record in the matter of the state of Michigan versus Elijah Bailey Thomas, 25-02481, appearance, please.
Thank you, Your Honor. Can I speak to you for the people?
Thank you, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Elijah Bailey Thomas, who is approaching out the table now.
As there is no Ms. Shavante Rembert here, the people are unable to proceed at this time, so I would expect a motion from the defense.
Thank you, Your Honor. At this time, the defense moves to dismiss for lack of probable cause.
Our motion is granted without prejudice. The people do have the right to reissue this against you. Do you understand that? Do you have any questions at this time?
No.
We'll get you a dismissal in just a moment, okay? And you're on GPS center? Okay, we'll notify them you need to go back down and have it removed. No problem. Now, this is the matter of the state of Michigan versus Shamron Thornton, 25-02486, appearances for the record.
Thank you, Your Honor. Can I speak to you for the people?
Assistant Public Defender John Lee appearing on behalf of Sharon
Okay, today was the date scheduled for preliminary examination. This is for assault with a dangerous weapon, police officer assault. There's also malicious destruction of fire or police property and a domestic violence. Are we running today?
Thank you, and I will defer to the defense if we are running. We have had discussions about how we be proceeding on this.
No, we are not ready to.
How are we proceeding?
My understanding, from my discussions with the prosecutor is that we will be waiving up on the two existing R&O and police destruction charges. Another charge will be added for attempted disarming. The assault with a dangerous weapon and a domestic violence will be dismissed.
That is accurate, Your Honor, and there would be preservation of the current offer, which is to plead to the counts of R&O and malicious destruction of property of police property.
Waiting on what again?
Waiving on the resisting and obstructing, on the malicious destruction of police property, and consenting to the added count of attempt disarming an officer. And I'm going to.
Waiting on count 1 and count 2
Yes,
and adding a count 5.
yes,
Attempted disarming a police officer.
yes, the PAC code being 250.479B2, I believe A at the end for attempt.
And then dismiss count 3 and 4.
That is correct, Your Honor.
Ms. Thornton. You understand that you're being charged with felonies here?
I do.
You understand that you have the right, because they're felonies, to have a preliminary examination, and the purpose of the preliminary examination is for you to require the prosecutor to establish that they have sufficient probable cause that these felonies were actually committed, and then probable cause sufficient to charge you as the person who allegedly committed those felonies. You understand that? You want to waive your right to have that exam? Anyone promising you anything if you waive your exam?
No.
Has there been any threats against you or coercion to get you to waive your exam? You're waiving it freely and voluntarily? Okay, you can have them sign it.
Your Honor, I realize I wrote down the counts in the wrong orders. I apologize.
I'm sorry?
I believe we spoke about the counts in the wrong orders. I believe count 1 was the FA that would have been dismissed. I apologize. I didn't catch that until just a second ago. I mean, actually,
I'll look at my, I don't think count 1 is the other. I think the count 1 in my file is might be assault.
it's out of our usual order.
I told you. Oh.
Oh, it's out of order in the file as well. It's so count
It's just
2
don't worry
and
about
3.
it. Sign it out to here.
Sorry.
Yes. Okay, so you're dismissing which counts?
Dismissing counts 1 and 4,
1 and 4.
counts 2 and 3, adding count 5.
One felonious assault is being dismissed. Count 2 police officer we're keeping.
Yes.
Adding to count 5, I have that on here. Malicious destruction of fire. Dismissing,
Keeping.
you're keeping. 2, 3, and 5 pending dismissed. 1, 4 being domestic violence. Bind over date's gonna be September 17th. That's the date the circuit court receives the file from the district court, not a day you need to appear in court, okay? Okay?
Yes, ma'am.
Your next court date's going to be a pre-trial in circuit court. Mr. Lee will be made aware of that date, okay? You stay in contact with them. Have an address for you ending in 2139, that's still accurate?
Yes, ma'am.
And I'm sorry, that was a phone number ending in 2139, and the address on Long Boulevard?
Yes.
Okay, it's your responsibility to update the court and your attorney with any changes to avoid you getting a bench warrant for failure to appear if for some reason you miss your court date or notice of a court date change. Do you have any questions at this time, ma'am?
No, Your Honor.
Your bond is 4,000 personal recognizance with GPS tether. That will continue as well as the no contact order. Any additional matters for the record?
Not from the people, Your Honor.
Only one other matter, Your Honor, in regard to the bond conditions, we would ask the court to consider the removal of the tether. Good faith in making 2 appearances thus far in the case, and the assaultive charges have been dismissed.
Charges against that victim have been dismissed, so I will remove the GPS tether. You gotta go back down to county to get that removed, okay?
Thank you.
No problem. Do you have any other questions?
No, ma'am.
Okay, any additional matters, counsel?
Not from the people, Your Honor.
Nothing to the defense. Thank you.
And actually, I misspoke. I gotta get rid of the no contact.
Oh, that's right.
You're all set.
Thank you.
Is everyone- This phone is ringing. Do you want to be found in contempt today?
No.
Turn your phone off. Is Mr. Palmer here?
Yeah, I'm right. I'm sorry, I'm the one hiding.
No worries. State of Michigan versus Jonathan Watson, 25-02483, appearance, please.
Thank you, Your Honor. Cassidy Kachukis with people.
Good morning, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Jonathan Watson, who is not standing to my right.
Why is that?
Your Honor, I don't have an explanation for what Mr. Watson's failure to appear this morning. I will say that he did appear for the probable cause conference last week. I have had several telephone conversations with him recently as yesterday afternoon, about how we were going to proceed this morning. I did specifically remind him yesterday afternoon that he had a requirement to appear this morning in person at 8:30 for preliminary examination. I have also tried to call him this morning. I tried calling him about 9:15 this morning to find out where he was, I should say, and left a voicemail advising him that he was about 5 minutes away from the court issuing a bench warrant. I have not, as we stand here now, I have not heard back from him. I do not have any further explanation.
Issue a bench warrant. By forfeiture. And we could hold it for 48 hours.
Understood. Thank you, Judge.
No problem. Any additional matters?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
State of Michigan versus Sean Williams, 25-01951, appearance.
Morning, Your Honor, Jennifer Lawton on behalf of the people. Good morning, Your Honor. I need your LB Longi for Mr. Williams, who is by my side.
That was scheduled for preliminary examination for criminal sexual conduct in the second degree. Are we ready to proceed?
The people are ready. I believe that Ms. Longi has a request for an adjournment.
Yes, Your Honor, I received as part of the discovery yesterday. We don't have the whole discovery yet. So I'm not prepared to, and I believe that these are substantial documentation that we need in order to prepare for the PE, especially also because the child is not going to testify. It's my understanding that they are receiving notice where the prosecution wants to have the grandmother testify, and we want to answer that notice because we don't believe that all the conditions for the hearsay to be admitted are there. We also believe that the grandmother is the one who's putting the information child. I do not have the forensic interview of the child yet. I only know what they say that he said. And reviewing the CPS investigation, I have some concern about what the child has said because what we need to see, I need to see what was the interview, what the child said in the interview, because from what I have from the CPS, it is my understanding that the child disclosed that he's not afraid of my client. He doesn't know what my client did to him. Let me quote. The child indicated that my client was rude to him, which is why we kicked him out.
You said he was rude to him, which is why what?
We kicked him out.
Okay.
He described Sean to be rude to him, as him scaring him all the time, but he was unable to describe how Sean scared him. He's just, I just don't like Sean for one reason. So we need to know what happened during the interview. What did the child say that the hospital will ask the court to allow the grandmother to corroborate what the child said?
Okay. My concern is I reset this all the way in July so that you can get additional discovery. Why have you not received it?
Can I respond to that, Your Honor?
Yes.
Couple of things. I was not present at the probable cause conference. There was another person from my office that was covering for me on that date. I had requested that a protective order be signed on that date for the forensic interview. I am unclear actually if that was signed at that time or not, but regardless, it did not make it into the file in my office. So that forensic interview was not sent because we did not have a protective order. During those entire 2 months.
Is this the protective order from July 24th that was signed?
Yes.
I signed a protective order in July.
And I don't know why my office didn't have that on record, but regardless, Ms. Wanji never reached out to my office regarding that until yesterday. At that time, I then sent over another protective order because I wasn't clear on whether or not we actually had one. I did receive that back from the court yesterday, and we informed Ms. Wanji that the forensic interview was done, ready to be picked up from our office yesterday. It is the people's intention, and I did file a notice regarding admitting evidence under MRE 803A. That is an exception to the hearsay rule that allows a victim who is under the age of 10 for the witness who was given the first disclosure to testify. That is the grandmother in this case. The grandmother can only testify to what the victim disclosed to her. She can't testify as to what was disclosed during that forensic interview. She wasn't there for that. So she can testify as to that first disclosure that was made to her. I do believe that that will be enough to satisfy probable cause in this matter. So I guess I'm unclear as to why the forensic interview is needed at this point to go forward on the exam as it stands today. However, I will leave that to the discretion of the court. I will admit that Ms. Monty has not yet received the forensic.
Okay, so you're, at this point, we have witnesses here, but not the alleged victim?
Correct. The alleged victim is 5 years old. He is unable to testify based on information that I've received from his guardian as well as his therapist. However, his grandmother, who is also his guardian, was who the first disclosure was made to. She is present and prepared to testify today.
Okay, so the alleged victim's unable to testify at this time, or that's indefinite?
I don't know if that is indefinite or not. He is currently in therapy and going through receiving therapy as a result of this alleged incident.
That's not correct. This child has been in therapy since he has been adopted. This is a child who's been in therapy. Even the therapist said that he's been therapist for months. So my client.
This is an adopted child. You said it was adopted when?
He was adopted, I think, in 2024.
Okay, and the entire time the child's been adopted, he was undergoing therapy?
It's my understanding that he's been going to therapy since that time. And so and also this is the thing, my parents and the grandmother are married and they're going through divorce. So it's our contention that this is part of that allegation about the child being molested. It's part of the grandmother being vindictive. And so we want to explore that.
I'm sorry, so wait, who's going through divorce?
The grandmother and my client.
The alleged grandmother and your client, you said?
Yes.
Oh, okay. Got it.
Well, that's something that they can cross-examine the grandmother about.
I need to be prepared to cross-examine the grandmother about that. I received the CPS report yesterday.
I understand. Receiving it yesterday probably falls on both of you for not staying on top of making sure the discovery was properly turned over. The court signed the order on the day of the hearing, which was July 24th, when the timeline was waived. I don't know why you didn't both get notice of that. Nonetheless, the timeline's already been waived. It's his right to have the speedy trial. He wants to delay it so that he can further gather information, and in light of the fact that we don't even have an alleged victim, I have no problem with resetting this. If the victim was here, I was not going to reset it.
I understood, Your Honor. Thank you.
November 14th at 8:30. November 14th at 8:30 work.
Yes, Your Honor. Thank you.
That work for you, Ms. Wanji?
It does, yeah.
Oh, okay. Any additional matters for the record?
Nothing else from the people.
Nothing, yeah.
Thank you.
Thank you.
You're all set. On the record in the matter of the state of Michigan versus Anthony Goodall, 25-02487. Appearance, please.
Thank you, Your Honor. Can I speak to some people?
Assistant Public Defender John Lee, on behalf of Anthony Goodall.
Mr. Goodall has a examination for police officer assault. You running an exam today?
That is my understanding now.
What are we doing?
We're going to be entering a plea.
What is the offer?
An offer has been extended at this time, Your Honor. It is that the defendant may plead to one count of attempt R&O under the understanding that the defendant will not seek HIDA.
He will not seek HIDA? He's not eligible, is that what you're saying?
Notice that he will not seek HIDA even if he is eligible. is part of the agreement.
Who would agree to that?
I'm sorry.
Who would agree to that?
Well, Your Honor, we understand that he already is on height of something.
Is he eligible for HIDA was the question.
Oh, gee, that's what you were saying. I'm sorry. I believe he is, yes.
Why in the world would he agree not to seek it?
Because he's getting the benefit of the misdemeanor.
Oh, okay. That's what he wants to do.
Your Honor, I have the police report.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can put your hand down. This is an advice of rights and plea information sheet. It's 2 pages. This is the signature page. Is that your signature?
Yes.
You went over these rights with your attorney?
Yes.
Do you understand all the rights here?
Yes.
And you want to give all of these rights up?
Yes.
Do you have another matter, Peggy? Before me?
The Jacob Raleigh case.
I'm asking, I'm only looking at the note. It says he's on probation before Judge Cole and bond for Judge Simmons.
Yes, he does have another matter pending before you. There are 2 cases. I'm looking right now at the charges. They are both for probation violations.
He's on probation before me?
Says he's got a bench warrant already. So.
Pre-trial. He's got a pre-trial before me.
Yes, Your Honor, I'm seeing a pretrial.
Yeah, I don't know
before
why it
you.
says.
Yeah.
What it says.
Yes.
I'm seeing a pretrial before you on Monday for B&E for illegal entry, and I'm seeing another one out of 55th. That's a retail fraud.
Got it.
Oh, those are not accurate.
Okay, sounds good. Okay, so you understand that you, in order to give up all of these rights, you would first have to understand your right to the presumption that you're innocent. So you're innocent until proven guilty. You understand that? You want to waive your right to be presumed innocent until proven guilty? That means you're giving up your right to a jury trial, your right to remain silent at trial and not have silence be used against you, your right to require that the prosecution establish beyond a reasonable doubt each element of the charge being brought against you, your right to question any witness they call to testify against you, and your right to see them in court, and your right to subpoena witnesses to testify on your behalf. You understand all of those rights? Anyone coercing you to plead guilty? Any promises if you plead guilty? You're on probation, you're not on parole, correct? And you have other court date or criminal matters pending, correct? You understand that by pleading guilty, it could result in or have impact on your probation status. It also could have impact on your employment. You may need to report this to your employer or to a future job application. You understand that? It also could affect your ability to travel to different countries. So you might want to go on vacation somewhere, they could deny you permission into their country because of these convictions. You understand that? Okay. As to the attempted police or attempted resist and obstruct, how do you plead? Is that because you believe you are guilty? Tell me what you did to make you guilty of an attempted resist and obstruct. Okay, and when was this? Was it September 15th? Because today is September 5th.
I'm sorry.
August 15th? Okay, where was this located?
Don't, the address.
Does Lenawee and Street in Capitol sound familiar at all? Okay, is that in the city of Lansing, state of Michigan, Ingham County?
Yes.
Okay, and why were you having contact with the police? You was just sitting there over in that area and they just walked up to you?
Yes.
What were you doing in that area? It was just there? There for what purpose? What is that? What is at that area? What do you mean nothing? Is it a business? Is it a park? Okay, so you were at the park and you were just hanging out.
Yes.
Okay, were you by yourself?
I was with a friend
You was with a friend hanging out. Were you sitting on the bench, standing? What were you doing?
standing.
Okay, and then police officers arrived? Okay, and did you have any clue why they were arriving?
No.
Okay, and so when the police officers arrived, what did you do?
Walked away.
You started to walk away? And then they gave you a lawful command to stop?
Yes.
Or what you believe was a lawful command to stop?
Yes.
Okay, and you didn't?
Yes.
Okay. Any additional matter or factual basis that is?
No, I think that's sufficient.
Nothing for the defense.
The court satisfied with the factual basis, I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. The matter is scheduled for sentencing October 31st at 9 a.m. When you leave here today, you go down one floor to check in with our probation department. They're gonna prepare a pre-sentence report about how you should be sentenced or how they believe you should be sentenced. And compile some information about what's going on with you in all these cases, okay? Do you have any questions at this time? Any additional matters for the record, counsel?
Nothing for the defense.
Nothing for the
Thank you, you're all set. One thing I noticed on my docket today is I had 6 police officer results. On the record in the matter of the state of Michigan versus Sergio Archer, 25-01873, appearance, please.
Thank you, Your Honor. Cassidy Chicken for people.
Morning, I'm Attorney Derek, and also the defender on behalf of Mr. Sergio, who is in the building in city lockup. I've already met with him to discuss this case, Your Honor, and I'd wait his presence being here.
Thank you. Today was the date scheduled for a preliminary examination for Mr. Archer. My understanding is that the necessary witnesses have failed to appear, correct?
Yes, Your Honor, that is my understanding as well. I've not located them here in this courtroom today. I've not had contact with them. So I would expect them to the best interest.
Your Honor, at this time, we'd ask court to dismiss the matter. The prosecutor could bring the case forward again if the witnesses are willing to participate. I told Mr. Sergio he does have other pending matters, including with this court, so he would not be getting out of jail anyway.
Okay, we will issue a dismissal in just a moment.
Thank you, Your Honor.
Thank you. The matter of the people of the state of Michigan versus Tammy Shaw, 25-02274. Is Shaw in jail? No. Jail, stick around here. Jail, Shaw's in jail. No, I don't have. Mr. Lee, I think this is your case. You have the remaining of my docket.
Sorry, yes, Cammy Shaw. I'm sorry, Your Honor, I have not seen her in the courtroom yet today.
Have you had communication?
Yes. But it has been probably a few days since the last time her and I spoke.
Okay, let's see here. I have been trying to cross to adjourn. She had something going on at 55th, then she's not here. Okay, well, how is your bench warrant?
Just so the court is aware, Your Honor, we are seeking to likely move this case to mental health court as well in 55th. And
You're likely to do what?
we are likely to be seeking to move this case to mental health court for in 55th District Court for a plea. So that should be remaining there, but I believe we need to find a way to do that, and we're still working on.
I'm not following. You're moving it for, I'm sorry, what are you attempting to do?
I'm not today. I'm giving the court a heads up that whenever she reappears, we will be seeking to probably move this to mental health court in
Oh,
55th
okay.
District Court.
Okay, so she's gotta be screened to see if she's eligible for mental health.
I believe she has been screened and found eligible. We're just waiting on the forms.
Right, I do see that she was being held in 55th, at least in the first appearance in this court. So just a referral to mental health.
She was released. She made contact with pretrial services. I'm not sure why she's not today.
Okay, sounds good. For Archer, I give that to his attorney.
Oh, thank you.
A copy of it that is on the record in the matter of the state of Michigan versus Christopher King, 25-02497. Appearance, please.
Thank you, Your Honor. Cassidy Chief for the people.
Assistant Public Defender John Lee on behalf of Christopher King.
King has a carrying concealed weapon, assault with a deadly weapon, and assault and battery scheduled for examination today. How are we proceeding?
Yes, Your Honor. People have not seen the necessary lay witnesses for the assault charges on this case and would expect a motion from the defense on that. However, it's my understanding that the defense intends to waive the right to preliminary exam on the CCW charge.
That is accurate, Your Honor.
Assault and battery and the assault with a deadly weapon is what you're looking to do today. Sorry, it was Misc Greer. There was two, who's the assault and battery on? Was Jordan Hewlett subpoenaed to be here today? Because that's a misdemeanor.
We verify. Yes, Jordan Hewlett was.
Okay, he wants to waive the CCW.
That is right. Yes.
You understand your right to have a preliminary examination on the carrying concealed weapons charge? You understand the purpose You have the right to require that the prosecutor establish that they have sufficient probable cause that a felony was committed and probable cause sufficient to charge you as the person who committed the felony. You understand that? Counsel, can you grab this for me? You wish to unconditionally waive your exam, correct? Anyone threatening you to do that?
No, ma'am.
Did anybody promise you anything if you do it?
No, ma'am.
I find your waiver to be freely and voluntarily made. Your binder was dated September 17th. That's the date the circuit court receives the file from the district court, not a court date for you, okay? Your next court date in circuit court is going to be a pre-trial. And Mr. Lee will be the one made aware of that. Is your address still 913 West Holmes?
Yes, ma'am. Office 259. It's my business.
What's your home address?
1221 West Lenawee Street. I'm supposed to be moving. My family has to move because of the city. The city is having a home. We're supposed to be on by 8, and we've been in the process of trying to move. And not only trying to move because of the rent, or I mean the landlord that offered since last summer.
So you want your mail to go to your office?
Yes, ma'am, please.
Okay, and your phone number, sir?
I have 2 of them. It's 517-326-9838 and then 989-209-7413.
20974.
13. Both phones be with you.
Okay, if you have any additional changes, especially to your address, it's your responsibility to update the court and your
Yes, ma'am.
attorney, okay?
Yes, ma'am, respectfully. Thank you.
Okay, a bond was
I think-
originally set 25,000, 10%. That will continue, we'll just remove the GPS tether.
Thank you so much.
And a bond, and the no contact order goes away because we don't have any victims here. Any additional matters for the record?
Not for the Your Honor.
Okay.
Thank you. You're all set.
I'm so excited.
What's wrong with these burger buns?
I'm gonna call Vanita Lloyd versus Lamar Lawrence. Case number C22G2833. Who's here on this?
Anthony Lukin for Miss Lloyd plaintiff.
Okay.
Never showed. Guy never showed.
Is Lamar Lawrence here?
He never showed. He's 6 hours late.
Okay, well, let me see here.
It's termination. We're not waiting for money. Should be able to be pretty easy to just dispose of it. This guy's majesty couldn't be bothered to show up for 6 hours.
Well, I don't have a real way of verifying that. Because I had a swap of court recorders in the middle of the day.
If he cared, he would have come in the middle of the day and he would have checked in and waited for the new court reporter. So either way, he's a dud.
You know, Mr. Lupkin,
Yeah.
I gotta tell you, the case is a dud.
Well, if you want to blindside me with some scolding, I'm ready. I don't know what the heck's wrong with it. I don't appreciate always having bad
Okay,
news all the time.
turn to your notice to quit.
Yeah.
See it?
Yeah, what about it?
Paragraph 1 is blank.
Paragraph 1.
They
I don't
either
know.
have to
I don't
check the
see it.
box that refers to the statute, or they have to check the box that says other and fill in that blank.
I think she checked the box. Maybe it came out too faint. Maybe she used a Sharpie, a yellow one. I mean, I understand like the punished landlord. This nice old lady. She's a nice church going black lady. She's everything fair and square. She doesn't cheat anybody. She's a sweetheart. And I know you like to slam everything landlords make mistakes
I like to
on.
follow the law, Mr. Lumpkin.
Well, I
And the
don't know.
law is that if the notice to quit or demand for possession is defective, then the court does not have jurisdiction to hear the case. So that's what the law is in Michigan. And I don't care what race or what church or how many times she goes to, I think I remember her appearing here years ago.
Yeah.
But let me, I'll go ahead and cite would you like me to cite the?
If you're going to turn her down, we'd like to have it in writing as to what was wrong, so I can give it to her and show it to her. She's the one who sent the notice. She has to know that.
Well, you're going to show her that she didn't check a box, right?
Well, if you say in your notice, relief denied for lack of checking off the box on number 1, then, that'll be good. I hate to have to wait 6 hours to find out something like this. So I was like, why can't do the quickies first and argue with people about their guardianship and their mental problems and their autistic children through the day? This is something I shouldn't have had to hear all that daytime TV to find this out. It'd be different if we had success after 6 hours, but much as I like you, I like your sense of humor. I know you're very thorough. Why can't you go through all the easy stuff and weed these out and then, slap us with the dud news early so I can tell my client.
Mr. Lufkin.
That's
Can
why
I
I want
ask
to
you a
retire.
question?
That's why I'm about to retire. Go ahead. What's your question?
You gonna retire?
Well, I'm only 68. I'm getting tired of this. But what was your question? I know I don't look that old. What was your question?
Oh my goodness! If you're gonna retire, have you ever thought about becoming a court recorder so that you can stack the cases the way you think they should be stacked with all that legal experience and knowledge?
If there's anything that's wrong, that's categorically wrong, you'd think you'd have a moment to just weed those out right off the bat. It's a matter of consideration. It's not really to say, I think you have a great conscience and a great social purpose and a great mission and a great spirit. So I don't want to knock it, but I just think that would have been nice to know. By grace of God, nothing better to do but watch Jay Powell in the Federal Reserve all day. So it didn't hurt. But in some people, it's probably wrecked their day having to wait this long. It didn't hurt me. I was at home. So but I just think it would have been nice to know. So please issue the reason for your denial so we can, or if you can adjourn it, I guess you probably can't, can you? Because you didn't put the right notice.
No.
Seemed to me like this is one of the punishments that these people who don't show up should suffer. Normally, if it's a defect, it's up to the defendant to bring it up. I don't know how, you ally yourself with the absent. It's different if the guy's present. God love you, but if he's absent, then it's up to him to say so. I think that's one of the problems we have.
Well, maybe Mr. Lupkin, maybe I'm like a machine.
Birmingham homeowners, did you know there are 8 different ways to sell your home?
Oh,
Maybe I'm like a machine over at the community college when people take a test and they fill in the bubbles, So maybe I'm just kind of like a machine. If the right bubble isn't filled out,
well,
they're marked wrong on the test.
But the problem is that if there's no one there,
that could be.
Normally, the judge isn't the advocate for the absent guy. If the guy doesn't show up, you can say you don't have jurisdiction, but actually, you have jurisdiction. It's just technically not filled out right. It's up to the absent guy or his lawyer. Or
It's not filled out right, which means, well, let me flesh that out.
You can
It's
decide how
not
you
filled
want.
out right, it's not filled out right, which means the defendant didn't get notice as to the purpose for wanting termination. The whole point of giving somebody a notice to quit or a demand for possession is for the landlord to be able to say to the tenant, hey, you didn't pay your rent. Here's how much you owe for a non-payment case. And of course, in a termination case, the notice is to say, here's why I'm kicking you out, or here's why I want you to leave. And that way, if you correct this behavior in a termination case, you can stay. Or if you pay that amount of money, you can stay.
There's no behavior that can allow them to stay. And number one is a statutory form. And the only reason why there would be occasion to check a box would be number two, which is the other, in case of any other reason besides the standard notice. And so it seems to me like you're looking for a requirement that isn't there. I'm not sure the law actually requires that box to be checked. I think it only requires that other box to be checked.
It does. Well,
you're the judge.
It does.
That. You can rule that, and I'll tell my client it's another 30 days.
So why is this person? What's the notice to say? I mean,
it says whatever the standard.
Wait. Just read the paragraph. Read the paragraph. It's an incomplete.
I'm answering you.
Never mind the boxes. Read the paragraph. It's an incomplete sentence without a box check.
No, it's still complete. It's that statute. Unless someone checks other, that's what applies. And you're just imputing a requirement to identify that the standard language has to be reaffirmed by the landlord, which I think is a technicality that you're famous for, and I respect that. I know you don't want to see landlords get away with cheap, sloppy things, and they are responsible for what they do, and blah blah. But I'm just saying, in a case where it's standard language or other, check the box. It's standard language. Let someone check the other. So that's why I'm saying, if you want to put up the resistance and say no, you have the right to do that. You're the judge. But I'm just saying that the use of the standard language and citation of the rule under number one is presumed unless someone checks a box indicating something other. So I'm sure that Judge Crawford or Judge Perry or some other judge, Judge Marsh, would understand that and wouldn't invalidate if the guy's absent and wouldn't even bother to show up, would not invalidate the whole thing. If the guy happened to be there and say, hey, this is wrong, I think he'd be entitled to, to be able to claim an argument, and then you could jump on it and say, I like his argument. Yeah, I'll give him a break, but he isn't even there. So number one, he isn't there to raise it. And we don't have standing to bring up his arguments for him. And number two, it's nothing in the law that says that you have no jurisdiction without that being checked off. It just says
that's not true.
Well,
check out Park Forest. Check out the Park Forest case, Mr. Lupton.
Park Forest, what? I need a citation. I mean,
sure.
I mean, I'm not going to argue with you. If you honestly, in your heart, as an experienced landlord,
Forest of Blackman versus Smith, 112 Mish 421, 1982.
Oh, Misc, you mean?
No, Michigan Supreme Court.
No, the Michigan Supreme Court wouldn't be 112. That was the 19th century. 112 Misc, probably. Well, you said 412. You said 112, right?
Well, maybe they wrote it down wrong in my bench book.
It's Misc, yeah. Anyway, and it says, and you're saying to me that it says that if they don't check off box number one, there's no jurisdiction.
Oh, Mr. Lupton, it doesn't say that.
Okay, well, you might want to.
The case doesn't say that. Listen, Mr. Lupton, I would love to have the opportunity to talk to you about this a lot further. And anybody could tell you, including yourself, that I dismiss cases for this reason habitually.
Yeah, I know, and that's why I appreciate you.
Routinely, habitually, routinely. So for me to do something different on this matter.
Well, you're quoting a case. You're quoting a case, 112 Mishap. I didn't get the last. What was the last part again? That one last bit, 112 Mishap.
Oh, my goodness.
I didn't hear it. It was faded out. Sorry. I enjoy bantering with you, but this is still, a little
It's a
much.
1982 case, 421, 1982.
112 Mishap, 421. Okay. There it is. Park Forest versus Smith.
Well, there's a whole line of cases there, but that's probably the leading case.
Yeah, well.
Notice requirements can be conceived of as two distinct conditions that must be met before the landlord may commence proceedings. The first condition is that the landlord convey certain information about his or her intentions to the tenant in a specified manner. That would be letting them know why you're trying to kick them out. The second is that they wait a specified time period.
Okay, but in that case, in Park Forest case, the defendant got notice to terminate, then they accepted rent afterwards. That was the problem. Nothing to do with this case. No one's accepted any rent afterwards. Not the same case. They made no mention of the fact that
Park Forest.
I'm reading it.
Well, there's a whole lot of things that Park Forest talks about. I got to move on, Mr. Lipton.
I'm just saying that.
But you got 21 days to appeal my decision. So we'll move on.
If you can please explain what basis was in your motion, that would be, in your dismissal, that would be helpful.
I told you, I told you, so this is the second time I'm explaining it, and actually the third time. Court lacks jurisdiction because the notice to quit was not proper. It did not inform the defendant as to why the proceedings were sought, and therefore the court lacks jurisdiction. In fact,
you can write that. I'm just saying that the Park Forest case decided the way it was specifically because the landlord accepted rent after sending a termination. So that case is distinguishable, and the reason why it was decided that way was not because the notice was deficient, but because he accepted rent, and that changed everything. So that's why you're relying on
appeal it. That box is up there. What does that mean? Marcia, that black box.
Oh, no.
Is she the judge? Landlord waives the right to enforce a covenant by accepting rent. Slinsky versus Gutstein. That was what that case decided on. Nothing to do with that little box not being checked. So that's not a good faith extension of that case. I'm willing to, work with you, but this is not right. You can't use that case as a citation. Yeah, they accepted rent afterwards. No wonder the guy was confused. Park Forest. We had nothing like that. Our guy was a complete dud, and you're letting him ride the feelings of his dudhood by ascribing rights to him that are not in the law and not in that case law that you said. Can you hear me? Are you there? Hello?
I guess I'm in the meeting now. Requell Person versus Jacqueline Johnson. KC, are we on? KC
Yes.
22G 3448 LT. Who's here on this?
Are we done?
Yeah.
I'm here, Judge. I'm here as well.
I'm as who? Identify
Jacqueline
yourselves
Johnson.
for the record. Starting with the plaintiff. What's your name?
Requil person.
Spell that, please.
It is spelled Requille. Last name person, Person.
Defendant.
Jacqueline Johnson.
Okay, so Mr.
JAC.
Jennings, let me. Okay, so Ms. Johnson moved in my property a little over a year ago, and we agreed that the rent will be $750. The state of Michigan pays $690 of her rent, and for the first 4 months, Ms. Johnson paid me the remaining balance, which would be $60 of her portion. And for the past 11 months, I have not received no payment from Ms. Johnson.
Well, have you applied for assistance, Ms. Johnson?
No, because my rent portion is $690 and I don't pay a portion, and my rent is paid through Becca Management. It's a Section 8 program.
Yeah. So what's the issue? Why isn't it paid?
My rent is paid. My rent is paid by Becca Management every month, $690.
Well, you know what? Ms. Person,
Yes, sir.
do you have your notice to quit in front of you?
Yes, I do.
You got the same issue as the last case.
What you said, what is not filled out correctly, Judge?
It is not. Look at paragraph 1 on your notice to quit.
Okay, when I went down there to fill it out, the clerk office actually helped me fill it out. So then we need to adjust that with the clerk office if they are going to be assisting us with filling out paperwork to fill it out correctly.
No. Number one, they're not supposed to be giving legal advice. And there's a big blue sign that says that, okay? Now, if they're giving legal advice, I guess you need to tell me who you talk to so that I can, ask their supervisor about that.
Okay, so what do I need to do from here?
Besides that, wouldn't you have given her the notice to quit before you came down to the courthouse to file the action?
Yes, I did. I gave her a 30-day notice before then.
Yes, you did on May 5th, right? So when did you say that the clerk told you how to fill this out?
I said they assisted me on filling it out the correct way, sir. I didn't say they told me how to fill it out. They never gave me legal advice. I'm sorry, they assisted me on filling it out.
Well, I don't know exactly what you mean by assisted. I don't know exactly what that means.
Okay, so what exactly was wrong with it, sir?
Okay, paragraph 1. You see it says, your landlord, landlady, your name, is seeking to recover possession of property pursuant to, in the next line, you have left blank.
Okay.
You have to explain why you are seeking to recover possession of property. So either you check the box that refers to the statute, or you check the box that says other and you write in the reason.
Okay.
You see what I'm talking about?
Yes, sir.
You're not going to tell me that one of the clerks told you to leave that blank, are you?
No, sir.
Okay. Because if they did, you would tell me, right?
Of course.
So it's blank because you didn't fill it out. Is that
Correct.
true?
That is true.
All right, because the notice to quit is defective, the court doesn't have jurisdiction to hear the case. That's, and I cited the law on that earlier, but if you want me to go through it again, I can.
Not at all. I've just filed another one.
The other thing I would point out, and this is not, I don't see a copy of the lease attached. Check out your complaint. You see your complaint?
Yes,
You see paragraph 2 of the complaint?
yes,
It says attached is a copy of the lease or occupancy agreement.
yes.
Well, you're supposed to attach a copy of that. You're supposed to serve her with a copy of that with the paperwork that you give the process server to serve. Okay?
Okay.
All right.
Have a great day.
Okay, how did the power?
Judge Morgan, before you go on the record, I reviewed the plea questionnaire with Mr. Martin. He had an emailed copy sitting in front of him, and then I read it to him. So that's how it's set up. And then I did send the copy of the deferred agreement, but we did the same practice with that as well.
Yes, I am going to tell you, Ms. Erdman, I do require that the document be filed by the defendant personally and then filed with the court. This one time I will print it and I will have you have it? Oh, okay.
The DGOCs, I don't know if that's.
I will print it.
Yeah,
and
I had
Mr.
him.
Martin, if you can come up here and get that and then sign it. First review it to make sure it is that document and then you can sign it. Yes, Ms. Erdman?
I was just going to explain. I had reviewed it. I signed off on it, and then I sent it over to Attorney Kevin for his review too.
Okay. So it has your name right there. So
And the document that I handed Judge Michelle was the DJOC for this as well as the other case.
Okay.
Otherwise, essentially, we're doing the same thing. I can, I just, what I try to do is I try to get all the information in before we start, if we can, and then So we
You
can
tell me
call
when
it.
you're ready, and then we'll be good to go, because I think that's just for efficiency of the court.
All right, yes, I will.
I like your hair, Miss Ford.
thank you.
New color, new you.
Yeah. Feeling it.
Okay, so while I have counsel here and
If you want to bring that up.
the defendants, I'm going to call these cases together. They are, I believe they're essential, well, unless you're not pleading to the same thing.
No, it should be the same.
Okay, so it's the same thing. So I'm gonna call the cases together and I'll go everything over, go over everything with both of you at the same time. If you need me to repeat something, let me know, but for ease and efficiency, that's what we're gonna do. And we'll try and go slow because it's harder for the clerk to be able to do 2 dual cases at once, okay? Just let me know when you're ready.
Yes, we should be.
We will go on the record in the matters 25 CF 67, State of Wisconsin versus Cheyenne Ford, 25 CF 68, 25 TR 37, 25 TR 237, 238, 239, and 240. State of Wisconsin versus Christopher Martin. This is a joint plea hearing as both parties are in a significant relationship together. They have children together. It's the same charges for the most part, but they are pleading to the same charges. And for ease of court and efficiency purposes, we are going to do a joint plea agreement. Off the record, the court informed the parties that this is what is going to occur, to listen very carefully because this is going to be for both of them. And if they have questions, they need to ask the court to briefly stop so that we can get it answered to make sure everything is done appropriately and correctly. All right. So appearing, we do have the state appearing in person through District Attorney Kevin Schmidt. We have Glenn Keene, Defense Counsel for Cheyenne Ford. Cheyenne Ford is here. We have Christopher Martin. We have appearing by video conferencing, Attorney Michelle Erdman, who represents Christopher Martin. For set for plea and sentencing, the parties have reached an agreement, and it is essentially identical, or is an identical agreement. I have deferred judgments of convictions and a plea questionnaires, or do I have two plea questionnaires? Mr. Keene, for the record, can you recite the agreement?
Yes, Your Honor. In 25 CF 67, and then in 25, in their case, it calls for Ms. Ford to plead guilty to counts 3 through 5, with counts 1 and 2 dismissed and read in for sentencing. The joint recommendation is below. Count 3, the felony, recommending a 2-year deferred judgment of conviction for 2 years with an administrative fee of $150. Conditions for successful completion of the DJOC is that parents must comply with the CHIPS case and achieve reunification, early termination of the DJOC, and dismissal of the felony if the CHIPS dispositional order is fulfilled and terminated prior to the 2-year mark. Regarding count 4, the neglecting a child misdemeanor specified harm did not occur. It calls for imposition of DNA costs, joint recommendation for 2 years of probation with conditions of an alcohol or drug assessment and follow through, compliance with the CHIPS order. And it would also allow for early discharge from probation should the CHIPS order successfully conclude. Per Wisconsin statute 973.093D2, the period of probation must be at least 1 year and all financial obligations must be paid. Count 5, the possession of drug paraphernalia, is for DNA and costs only.
All right, so count 5 is for costs only. Okay, all right. So 5 costs only. All right, and Ms. Erdman, is that the exact same agreement that Mr. Martin has reached with the state?
It is, Judge. When Attorney Keene was reciting the terms, I think it's clear to everyone, but the completion of the 2-year deferred agreement successfully will result in an outright termination regardless of the status of the CHIPS, I think, is the only.
Does your dog's breath smell like shit? This product is for you.
For clarification, yes. All right, thank you. Okay, now, Ms. Ford and Mr. Martin, I'm going to go slow so that you both can understand. And then I'm going to have one of you say the answer first, and always, Ms. Ford, you're going to respond first, and then Mr. Martin for ease of the court reporter, okay? All right, so I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over this form with you thoroughly?
Yes.
Yes.
Did your attorney read this to you essentially word for word?
Yes.
Yes.
Do you understand everything completely?
Yes.
Yes.
If you didn't understand something, did you ask your attorneys to explain it?
Yes.
Yes.
And they did so?
Yes.
Yes.
Did you sign that plea questionnaire?
Yes.
Yes.
You are pleading guilty to 3 counts. Count 3, which is a felony, count 4, which is a misdemeanor, and count 5, which is a misdemeanor, correct?
Yes.
Yes.
As to whether or not you have a high school diploma, and if you've had any medication or alcohol or any mental illnesses or disorders, what's checked on the form is accurate, correct?
Yes.
Yes.
Because you're charged with crimes, you're entitled to constitutional rights. Each of those rights is listed on the first page of that form. Did your attorney thoroughly go over those rights with you?
Yes.
Yes.
You understand them completely.
Yes.
Yes.
If you did not understand your rights, you asked your attorney to explain them.
Yes.
Yes.
Do I need to explain them to you any further?
No.
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes.
Yes.
Do you understand you're pleading guilty to a felony if the court either does not enter the deferred judgment of conviction, or if at a time the judgment of conviction gets revoked because of non-compliance? Do you understand that at that time the felony will be entered and you will no longer be able to use or possess a firearm for life?
Yes.
Yes.
You wouldn't be able to vote in any election until your civil rights are restored.
Yes.
Yes.
Here, in this case, as to count 1, possession of methamphetamine, the state would have to prove on or around April 28th, 2025, that you possessed a substance and the substance was methamphetamine.
They're not pleading to count
Oh,
one.
3. It's not that. It's, yep, sorry. It's
I'm sorry
count
to
3,
interrupt.
sorry. Nope. Great that you did this. I'm going to tell you, it's more difficult than I thought to do a joint plea. As to count 3, neglecting a child, specified harm did not occur and the child was under the age of 6. Do you understand the state would have to prove on or around April 28th, 2025, that being a person who's responsible for the welfare of a child, KM, date of birth, July 20th, 2022, through your action and failure to take action for reasons other than poverty, you negligently failed to provide so as to seriously endanger the physical, mental, or emotional health of the child, and the natural and probable consequences of this violation would be harm, although harm did not occur. Do you understand what the state would have to prove?
Yes.
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years, or both?
Yes.
Yes.
Do you understand that as to count 4, neglecting a child, specified harm did not occur, the state would have to prove the same date, the same time, the same place, that being a person responsible for the welfare of a child, EM, date of birth, October 6th, 2017, through your action and failure to take action for reasons other than poverty, you negligently failed to provide so as to seriously endanger the physical, mental, or emotional health of the child, and the natural and probable consequences would be harm, although harm did not occur. Do you understand that this is a misdemeanor count?
Yes.
Yes.
And you understand what the state would have to prove?
Yes.
Yes.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months, or both?
Yes.
Yes.
As to count 5, possession of drug paraphernalia, do you understand the state would have to prove the same date, time, and place you knowingly possessed with the primary intent to use pipes, plastic gem baggies, burnt tinfoil, and cut straws to inhale, ingest, and store a controlled substance? Do you understand what the state would have to prove?
Yes.
Yes.
Do you understand that upon conviction, you could face a fine of up to $500 or imprisonment of up to 30 days, or both?
Yes.
Yes.
Do you understand that there is an agreement between all of the parties here, the same agreement, And there is a recommendation for the court to adopt a deferred judgment of conviction for the felony, place you on probation for count 4, a misdemeanor, as well as count 5 for costs only. Do you understand? I'm not bound to follow that. I don't have to follow it. Do you understand that?
Yes. Yes.
So if I thought, based upon the facts of this case and other facts and evidence and testimony about you, that a different sentence should be decided, including jail, do you understand that I can do that?
Yes. Yes.
Do you still wish to proceed and enter guilty pleas?
Yes. Yes.
Did your attorney go over the criminal complaint, and that is the facts alleged in that complaint with you?
Yes. Yes.
And for the most part, are those facts accurate?
Yes. Yes.
Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Ms. Erdman, may I do so as well?
This is why I want my money back from Plateful. I paid full price for their viral Mace.
All right. So has anyone made any threats or any promises to you for you to plead guilty today?
No. No.
You're doing so freely and intelligently and voluntarily.
Yes. Yes.
Has your attorney represented you competently?
Yes. Yes.
Have they answered all of your questions?
Yes. Yes.
Have they looked at this matter thoroughly?
Yes. Yes.
Are you satisfied with their services?
Yes. Yes.
Any questions for the court or for your attorney before I proceed?
No. No.
And Mr. Martin, directed to you, your attorney's appearing by video. You had indicated you were okay with her appearing by video, knowing that you have a right to have her be in person. Are you still okay with that?
Yes.
Even with the sentencing?
Yes.
All right. So based upon that, the court will ask Ms. Ford first as to count 3, neglecting a child, no harm, and child was under the age of 6, an I felony. How do you wish to plead?
Guilty.
Mr. Martin?
Guilty.
As to count 3, neglecting a child, specified harm did not occur, a class A misdemeanor. How do you wish to plead?
Guilty. Guilty.
As to count 5, possession of drug paraphernalia, a misdemeanor. How do you wish to plead?
Guilty. Guilty.
The court will find your pleas of guilt for both parties is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find both of you guilty of count 3, count 4, and count 5. As to counts 4 and 5, a judgment of conviction will be entered today. The court will consider whether to adopt the deferred judgment of conviction for the felony. Mr. Schmidt, argument.
I think the court can probably infer what I'm trying to do with the structure of how I did this. These are the only parents that EM and KM are ever going to have. We have to work with them to make sure that both Cheyenne and Christopher are going to be able to take care of them, that they're going to be safe, and even more than that, that they'll thrive in the future, that they'll have a happy childhood and grow into happy adults. We had a CHIPS case not that long ago with these same children, with these same parents, with really the same sort of allegations. They crushed it. They got sober. They demonstrated they were capable parents. We know they're capable of that. Unfortunately, the sobriety did not hold after the completion of that CHIPS case, and this second case started. That's why we're doing more structure this time. Nobody doubts that they're going to be able to demonstrate sobriety again, that they're going to demonstrate they can take care of their children again. That's going to happen. I want to make sure that we have these criminal cases here as both a sword. There's a tremendous amount hanging over their head with these 2 cases that are going to have probation or the DJOC. The paraphernalia is really only there to allow me to do 2 years probation on the misdemeanor child neglect. That's why it's there. But also a carrot, because we've tied the resolution to the probation and the DJOC to the disposition of the CHIPS case. With the DJOC having the clause it can end early if the dispositional order is completed, and the same for the probation. The reason for that is if we should tie the conclusion of, state of Wisconsin versus Cheyenne Ford and Christopher Martin to anything, it should be tied to in the interests of EM and KM. It should be tied to what's best for those children. And by tying it to how that CHIPS case, where we get to have that as the primary goal in a way, we can't necessarily in this criminal case, because that's not McCleary Galleon. I think that's the best way to achieve the best results for the community, for the victims of this case, the children, and for the rehabilitation of the parents. I'd ask the court to follow this. I don't normally push like a hyper-specific structure like this, but in this case, I really want to do that because I want this there. I want the possibility of DOC resources to complement CHIPS resources if we ever need it. We really see that working out really great when we do treatment court, where we have those DOC resources complementing treatment court resources. I like the idea of trying that here with county DHS resources, with state DOC resources. I think that relationship, that combination of services can only serve to the benefit of the children, and that should really be the goal here. Thank you.
Thank you, Mr. Schmidt. Mr. Keen?
Yes, Your Honor. When looking at the sentencing factors, this case, as D.H. Schmidt pointed out, does focus on rehabilitation of Ms. Ford by, encouraging her to comply with the CHIPS conditions, which are, and having an alcohol or drug assessment. It also focuses on protection of the community and specifically the children by having that sword hang over their heads. The only thing I would like to mention is that it also does have some punishment element, because until today, Ms. Ford had only had traffic offenses in her life. Today, she has a misdemeanor conviction if the court abides by the DJOC, and obviously felony if the court decides not to. It also has an occupational bar, because once you have a misdemeanor conviction for neglect of a child, that bars you from working in the childcare industry, opening your own daycare, et cetera, and that's a permanent bar. So while this case is not focused on those items, I just wanted to note that it does have, some punishment aspects, so that factor is met as well. Although fortunately, it is focused more on rehabilitation and protection of the community.
Thank you. Ms. Erdman?
Judge, I guess I echo a lot of what prior counsel has said. The only thing I would state for Mr. Martin is that he's really just, again, I think Attorney Schmidt mentioned that the parents did exceptionally well the last time. And this time, I think he's really knocked it out of the park in terms of his achievements, the things that he's doing. I don't want to take anything away if he wants to inform the court about his education or anything, but just to say he's doing really well.
Thank you. Ms. Ford and Mr. Martin, I'm going to give you both an opportunity to make statements, to tell the court anything you want me to know. Candidly, I know a lot because I've been on all of the cases. But tell me again, because whatever you want me to know, I want to know before making any type of sentencing decision. Ms. Ford?
I wasn't really prepared to go first.
Mr. Martin?
Oh.
There's just been one thing that we've kind of wanted everybody to know. Is we've informed Kaylee about this from the beginning. Our first case around, I wish we could say that we were sober, but
This robotic puppy looks so real, it completely fooled my neighbor.
how do I say, the lack of effort from that social worker that we had, and being the addicts that we were, it gave us the opportunity to still use that entire time. We could time it up. We were timing things up perfectly. Being an addict, we were very opportunistic, I guess. So like I said, I wish we could say we were sober that whole time, but we weren't. We were not. This is the longest that we've been sober. This is the longest I've been sober in over a decade. And now that we have this support system, now that we took in, that experience that we did, that we went through for just that month. I mean, it's changed everything. You know, I went there with the mindset of like, all right, I'm gonna go do this for the court, make it look good on paper. First week went by, and it's one day something just clicked, you know, and it's something that I've embraced. You know, every day is a struggle still, but just being able to fall back on those foundations that we learned, the support systems that we've gained, it's changed everything. You know, so that's just one thing I wanted to say is that the first time around, I wish we could say we were sober, but we were not.
I applaud your honesty. I truly do. And I'm going to say that it's not just you who has done that in the past. People who have substance abuse disorders do that. They know when to time. Not all of them are as honest and open as you. So I applaud you for that. How many days have you been sober?
I think I just broke 130 days.
That's amazing. Good job. I'm very proud of you.
Thank you.
Ms. Ford?
So, right around the same time with his sobriety, I can't tell you exactly the date. I mean, the date after the arrest. But I will say, and this is something that I had told to our caseworker, that sadly, this is something that I needed. I needed this to happen, as terrible as it was. Needed it to happen to get the help that I needed and to be able to raise the family that I know I can. And like he had mentioned, it, you know, something clicked, and it's like, why did I even do that? Why, you know, what was I thinking? Because honestly, this feels great. This is amazing. And to see my children now thriving, it's great. And, you know, not to have to worry about this or that, or, you know, going to figure out how I'm going to get here or there. I don't have that worry anymore, and I can just focus on my children 100%. And I haven't been able to do that, and it's great.
Man, I'm just so proud of both of you. I truly am. I truly am so proud of both of you. How many days have you been sober?
I mean, since the arrest, so after April 29th.
Same sobriety date.
Yeah.
April 28th.
Yeah.
I am so proud of both of you. I truly am. I'm going to tell you, this job gets daunting at times, and it causes a lot of lows a lot of times, because I get invested in the people that are in front of me. And so it really brings me down. And I don't want to say it makes me a cynic or somebody who doesn't believe that change can happen. I do truly. But when I get invested and I see people, and then I see the dishonesty, like you said the first time around, you had it timed, you had it good. You knew how to, quote, beat the system and still be able to use, because that is what was driving you. Meth was controlling both of you, and you took control. You controlled those demons, and you are at a point right now where you have the ability to make the greatest life possible, to have a great, you're not married, but to have a great relationship together, and to have a great family together, and to raise two beautiful children. I got the pleasure to meet them that one day. They are beautiful children. You should be so proud. And again, so proud of your daughter. I'm extremely proud of your daughter. She did a good thing. And you two are here, and the demons were controlling you. Meth was controlling you, but you are now taking charge, and you're going to school, and you guys are starting this business, and you're doing all of the things to improve your life and your family. And it can only get better. It can only get better. I agree with you, Mr. Martin. I don't know personally how it is and that struggle, but I hear it every day, every single day. I hear it and I know it about the struggle of sobriety is an hour by hour until you can go a day by day, and then you build and you can go a week by week. You are constantly working on yourself and constantly dealing with the triggers and all of the things that are trying to draw you back to methamphetamine. You are conquering it. You are knocking it out of the park. I have never been so proud of two people in front of me. When I saw you the first time, I'm not gonna.
There's a simple brain trick that anyone can use to fight memory loss.
I didn't know for sure, but I had very strong suspicion that you were still using. I see people every single day. I can tell when people are sitting there high or they are still under the influence. But my job is not to call them out every single time or to send them to jail or to do those kinds of things unless it's a time to do so. And I have done so. But the fact that you are admitting that, and you have admitted that, that takes power. That takes strength to be able to do that. So keep moving forward. These charges, you know, are serious because they do involve your two children, and you did put them in harm's way. Thank the Lord nothing happened, and that your children didn't accidentally ingest the substances or anything of that nature. You have a great history in front of you. Ms. Ford, unfortunately now you have a criminal record, but that doesn't mean that it needs to define you. You can move forward from that. You can have your story. Now you both can go and share your life and your story and the lessons you learned to others. You can help others in their sobriety. You still have a long time to be able to totally get control over yours. You do have great control, but again, as you said, it's a day by day kind of thing, but you can help the community. And that's amazing. And that is great. With this agreement, I don't think that the community is going to be at risk. I think it's actually going to do good because then you both get to avoid having a felony conviction. And then you can continue on with your success and your great stories and the things you want to do. So with regards to the matter, I will adopt the deferred judgment of conviction. Again, you understand each of you must pay $150 within 60 days. Do it because that's the number one reason I see the state asking to revoke these. So do that and make sure you comply with all of the other conditions. You must comply with CHIPS, but I'll go into that. All the things that are in the DJOC are going to be in the probation, so I'll just wait for that. With regards to count 3 or count 4, that I'm going to sentence you to 2 years of probation. You must follow the CHIPS order, regular drug testing, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol. Any other condition that your agent deems appropriate or that your caseworker deems appropriate. $443 in fines and fees. As to count 5, I'm only going to assess $200 as the DNA surcharge, as that is a mandated charge I must assess. I'm going to dismiss, or I'm going to waive the rest of the court costs and fees. You already have enough things to worry about than all of the money that you're going to need to pay. You're each going to have your own separate accounts, but you can pay it all together in one, maybe 2 checks. I don't know how you're going to have to pay it with the clerk's office. But with regards to that, I'm going to assess $50 a month per person. That's a low enough amount that you can still support yourself and your children, work on your sobriety, and move forward. If you fail to pay, not only will the court enter a civil judgment against you, the court will issue a warrant. You could sit up to 6 months in jail. It's very important you at least make your monthly payment until it's paid off in full. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need your DNA, so both of you will need to go to the Sheriff's Department and see if they need that, provided if they do. And you have the ability to request it be expunged through a written letter to the Department of Justice. not to the court, but to the Department of Justice. I need to verify your address is still on West Hurdle Drive.
No.
Oh, well, let me see if I have yours correctly. What is your address then?
7111 Loon Creek Circle, Danbury.
Okay, and I have a telephone number ending in 9109 for you, Mr. Martin.
Nope.
Well, then I do have another one. It ends in 1410.
Nope.
Okay, may I get another one?
715-214-8802.
8802. May we send you text messages if we need to?
Yeah.
Ms. Ford, I will update your address as well, and telephone number ending in 2362.
No, just use the one that you took for him, because I don't know if I'm gonna stay with my phone provider.
All right, that sounds good. So 715-214-8802. I think that covers everything. What am I missing, Mr. Schmidt?
Nothing from me.
Only thing I'd ask, Your Honor, is for,
I forgot to state on the record. Thank you. Sorry to interrupt, Mr. Keen, that with regards to the chips as well as with probation, that if you successfully complete all of the conditions, you stay sober, you do all that you need to do, you pay off all of the fines and fees in full, the court I will not object and I will sign off on early discharge of probation and early discharge of the deferred judgment of conviction, all right? But as I don't know if that's exactly what Mr. Keen said, but the statute, and it's up to the Department of Corrections if they are going to allow you to discharge early. I just sign off on it. So you must meet all of those conditions, etc. They cannot have early discharge until at least half of the probation has been set. So you must have at least 1 year of probation and do all of these things, okay? Sorry, Mr. Keen.
yes, Your Honor, for Ms. Ford's case, she mentioned that she's not presently employed. And I was going to ask that $150 of the 500 cash bond posted, if that could be placed with to cover the DGAOC administrative fee.
I forgot that there's cash. Is there 500 each?
Yeah.
So you each posted 500?
Yep.
All right. What I'm going to do is I will direct the clerk to send $150 per case over to the district attorney's office to cover that fee. And then you will have $350 more that has been paid off. And so just continue your $50 a month payment, okay?
Okay.
Anything else, Mr.?
There we go. Yeah, I hope so too. But that's it for today, ladies and gentlemen. Trin, I'm glad to have you back. Anybody that was in here, if you decide to misbehave, I got all my mods in here. So that's it for today. Tomorrow is our landlord-tenant docket. I look forward to that. So I'm going to buzz on out of here in a few minutes. I appreciate everybody that does come in and watch. It's just a lot of work. I'm having to do a lot more work setting up live streams. So, you know, if you're not a subscriber and you like this content, please consider subscribing to this channel and helping this channel grow. And don't forget to hit the like button, you guys. I noticed that the likes are not like they're supposed to be. Well, that's it for today. Ta-ta and ciao-ciao. I will see you guys tomorrow at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. You all have a wonderful rest of your evening. And for God's sakes, try to be good.
From the mountains high, come down to it all with your
your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.